maybe selection based upon salary, wages, and there's still, time for that to maybe still be changed. But as of right now, that's still what's on the horizon for next year. And so a lot of people have, been filing this year, maybe some OPTs, some students have filed with a couple of different employers. So the numbers are up in that regard. And, it's just everything's moving forward. It's still, much more efficient than the previous ways of doing things where we have to print out all the petitions and mail them in. And, this is much more efficient. You can do a lot more work with a lot less mistakes. So it's much better.
Yeah, that's true. It means it reduces a lot of physical work, and the verification. Verification is a very important to apply any applicant to USCIS.
Correct.
So just roughly, I'm not sure, but just last year around we got 190,000 application for CAP 2021. Do you have any number to expect? Just rough extra.
I think we'll surpass that number. I think you'll see well over 200 to maybe 220,000 probably. And, if I was briefly speaking about the CAP, I do want to address a few points there. I've actually been receiving messages almost daily from various, candidates who might be applying for the CAP. And there's message boards where maybe, someone else who's going to apply is working for a single employer, like full time. And, they'll message the people or tell them that all these bad things are going to happen if they have two companies who are going to file for them, which is not true. And so there's a lot of competition, more so this year than in years past. So, we'll see how things turn out. But I really believe that also foreign filings are going to be much higher this year due to the registration process. So I really think that we're going to eclipse the 200,000 plateau and go probably a little bit further beyond.
Okay. So you were saying as a duplicate petition, let's say if any applicant, maybe knowing or unknowing, apply the two applications, if USCIS find, hey, you applied the two petition, the applicant, USCIS request any additional information from the applicant, or
no? So the way the process works, so in the years past, you might have two petitioners petitioning for the same beneficiary. And, if one's picked, then the beneficiary would go with that employer. There was a case 3 years ago called Matter of S, where this, one company used the same MSA PO and filed with 2 or 3 sister companies for the same employee. And USCIS basically came out and said, well, even though technically they're all separate companies, they're all still the nexus of everything is so similar. For management's the same, the contracts are the same, maybe the office locations are the same, that counts as a duplicate petition. Now, the good news about the registration process is a registration is not a petition. A registration process just allows the petitioner to register the beneficiary for a potential petition filing. And once the beneficiary is selected, then that would count. You pretty much have permission to file. So, if you're selected, which we saw this last year, the CAP was run in 2 batches. First batch, maybe there's quite a few people who were selected by multiple times with different employers. And then they, picked one employer to go ahead and file their case with. Those unused slots were then reissued in the second lottery that ran late summer, early fall. And, it's much more efficient that way. The only issue with duplicates with this system is if a petitioner accidentally enters your name twice with your passport, your birth date, then your registration will be denied. So that's really the only downside to the duplicates in this new system.
Okay. It means preliminarily they could not enter the same information twice for different company or same company?
Different companies. So in the past, what it would be is, we would send the LCA, the I-129, all the supporting documents we would mail in before April 1st or whatever the dates were. And, be open for 1 month. And so sometimes one petitioner might have a sister company. And so what this would mean is it's the same ownership, the same control, but it's two completely separate entities. So this new rule that came out a few years ago basically said, if everything's the same, like you have the same contracts, the same MSAPO, the same end client, all those facts are the same job duties and description, then it's going to be deemed as a duplicate. Now, we don't really have that issue anymore because with this registration process, I haven't heard of anyone filing two petitions for two different registration selections. Once you're picked, it's best just to go ahead and file for the one you're picked. And if you're picked multiple times, you have the choice to pick which company best suits you to go with. So, really no one would be filing duplicate in that sense anymore. It would just be basically we have multiple registrations.
Okay. So this news process, just we need to enter the very minimum information. Which information required from the applicant for apply? It means enter into the USCIS portal.
Well, the petitioner is going to have to share the first name, middle name, last name. We're going to need to know the date of birth. You're going to need to know whether or not it's male or female. We're going to need to know passport number, the country you're born in, the country you're a citizen of. And finally, we're going to need to know if you want to file in the master's quota or the general quota. And those are the only required elements to this filing. And based upon those, elements, then, your case, once it's submitted, you get a case number. And the lottery process is conducted based upon that case number. And if you're selected, you'll receive a selection notice. It looks much like a receipt and basically tells you when and where to mail your petition. So it's much more efficient in that regards.
Okay. Just you said there's a case number. It created the new case number, right? If applicant want, it means the employee can share the case number, or is there any restriction to not shareable info?
Well, so we can share the case number. That's what we do. We maintain, the information to where it's as transparent as possible. Unfortunately, you have to log into the website to be able to access that information. So there's no way a beneficiary or an employee could check on their own what the case status is. They're pretty much going to have to rely on the employer telling them that their case has been selected.
Okay. Though applicant know the case number, but they could not track their petition, right?
Correct.
Okay. So when USCIS start the lottery,
this year,
March 25th is the final date to complete the enter information into the USCIS portal by noon. But when USCIS is going to be start lottery system?
Well, so what it's announced is they're going to run the lottery by the 31st, and all, selections are going to be notified by April 1st. So I think last year we received notifications earlier than what was posted, but so they have, a few days to run the lottery. I would assume if the lottery closes at noon on the 25th Eastern time, probably by as soon as that weekend, or because it's a Thursday, I believe that it closes. Then I think last year we received some notifications on Saturday, and then early part of the following week. So usually, and we've only had this 1 year. So as of last year, pretty much all the selections that we know of were done before the actual posted date of when they would have it completed.
Okay. By April 1st, everyone get know their petition, the application will pick up or not, right?
Correct. Okay. And just like last year, I told people, just because you weren't selected the first go around doesn't mean, all is lost. The second lottery will be conducted towards the end of summer. So we'll have if whoever's selected in the first selection, we have probably until the end of July, I think. I don't remember the exact date to file. And then they'll rerun the lottery again in August. And then we'll have from that point till the middle or end of November, if I remember correctly, to go ahead and file the second batch.
Okay. Yeah. Thanks, Lucas, for more information on CAP 2022 process. Let's go for next topic, or MTR. So this one is the previous H1 denial, right?
Correct.
Yeah, you can share information.
Well, this is really good news. You and I have discussed this over the past couple of months, where USCIS has rescinded certain memorandums. Last year specifically, ITServe successfully sued USCIS and was able to have the new field memo and the third-party offsite memo rescinded by agreement, by settlement with USCIS. Also, here recently, there was another lawsuit where the use of computer programmer SOC code 151131 is also now considered. That memo was rescinded, and now that's a valid SOC code for qualification for specialty occupation. So that's also happened. So anyone who's had denials by those three memorandum in the past, now we can file a motion to reopen, even though the a lot of times already expired. You're allowed to go ahead and file a motion to reopen, and USCIS will take that or should take that into effect based upon their own statement and reopen the case, and then approve it if the denial was solely based on one of those three memorandums.
Okay. So just one scenario, Lucas, on this situation. Let's say one H1 applicant extension applied for based on the project timelines. Maybe USCIS consider only what is the project last ending date, or whatever the PO ending date, right? Mm-hmm. Let's say one applicant extended with 1 year of the PO end date in 2019. Let's say it's denied based on this situation. If he want to reopen the case, will he get any extension? Already 1 year of period is completed. The USCIS will consider and will give us some grace period, or maybe some future date, or how does it work if applicant want to reopen the case, same case?
What you're saying makes sense. Usually, if you only got 1 year approval and you requested 3 years, whatever is requested in the petition is the only thing you can go back to. So, if there's been a little bit of time, or you filed a subsequent extension, there's not really any use for someone filing an extension to go ahead and file the MTR. Where this is really going to come into really impact and help people is, let's say last year or 2 years ago, specifically really 2 years ago, let's say you filed for the CAP and your case was denied. And it was denied because of third-party offsite employment, that you didn't have all the client letters and all the contracts required by USCIS to establish the availability of specialty occupation work for that petition. So let's say you filed last year in the lottery, you weren't selected. You're filing again this year in the lottery. You don't know if you'll be selected. So if you still are on good terms with the same petitioner, that would be the main application where we would want to go ahead and reopen or file the MTR, because you don't know if you're going to be selected in this year's lottery. So if someone who's probably already on CPT at this moment, they had that one chance a couple of years ago, case was denied, they haven't been selected again since, that would make sense to go ahead and file the MTR in that circumstance.
Okay. So what is the current situation for H1 extension? USCIS requesting all employer details, or?
No, it's gone back to the way, the law says it should be. That's pretty much, you just have a preponderance of the evidence, which is, like a 51 to 49% establishment of the facts on the record to show that the position qualifies for a specialty occupation, that the beneficiary has a minimum of a bachelor's degree in a specific specialty associated with that specialty occupation, and that there's no other issues maintaining status. So, to prove this now, all we have to really show is an MSAPO, maybe a vendor letter, client letter, your payroll documents to show you maintain status, in your education documents. And these are really all that's necessary now. We don't have to, send the 200-page extension petitions any longer with all the project documents and, the life story of everything. So it's much more efficient now. And it's actually, if we request 3 years, the beneficiary is always getting a 3-year extension.
Okay. Yeah. Thanks, Lucas. And we can go for the next topic is new legislation. Is any good news?
There is good news. You and I have been discussing for a while about the comprehensive immigration reform, and I know a lot of people are that listen to our show might be, kind of pessimistic to the idea because of so much hope and then canceled, and then hope for something new and canceled. But this is really the best chance we've had in the past 10 years in regards to immigration reform, comprehensive immigration reform. And you and I discussed, I think, a month ago or so about a strategy this president's going to have to try and help pass this legislation to get everything through. Instead of putting everything together in one bill, what they're doing is they're going to piecemeal. And what piecemeal means is there's two bills that are being introduced this week, I believe either tomorrow or Friday, that's going to focus on the DREAM Act, the Dreamers, and also a bill to help fix the temporary workers for agriculture or labor. So H2A, H2B visa holders, and also people, who are here with DACA, Deferred Action for Childhood Arrivals. And, these will go through, and hopefully, whatever positive or negative impact these receive from both the public and maybe other members of Congress, it'll be independent of whatever is going to be passed for EB backlogs and everything else. So what this means is it's very, even though we would prefer that most of our listeners would prefer the EB backlog to be addressed first, what this means in the sense of being good news is it's not all or nothing. So the best way of going through it is if there's enough pushback as far as the Dreamers or these other farm workers or something else where there's not enough support for it to pass and it doesn't pass, well, it doesn't mean all hope is dead. That means they're still going to go through and address the EB backlog, and the merits of that are going to be independently evaluated. So there's not going to, there's a lot of positives that I think EB backlog would receive more support for from mostly the public and most members of Congress compared to, some of these other issues that come up. And so we'll have to, wait and see. But, the next 6 to 8 weeks look very promising.
Okay. After 8 weeks, we can expect more good news on EB backlog.
Yeah. Knock on wood. I hope so, but we'll have to wait and see. It typically is standard, even if everything's goes through perfect and is passed. Typically the government has 180 days to implement those changes. So we're still hopeful that we have something to look forward to before the end of this year to be implemented.
Yeah, hopefully we will get. Lucas, we can discuss one is the 485 adjustment updates, which we applied in October. So, do you see any biometric who downgraded to EB2, EB3? Do you have any information?
Well, yes. So, like what we discussed before, I've had quite a few people already receive biometrics, and it really depends on where you live. So, I know you're in Houston. Houston is independently a large city with 4 million people, and a large percentage of the 4 million people might require biometric services as far as like, being an immigrant or non-immigrant going through the process. So it's a first in, first out system. So if there's a greater population and a greater need, the line's just that much longer. I've had people who live maybe in Omaha, Nebraska. There's pretty much not many people who require the services. So if you happen to live there, it would be much faster than if you're in a large multicultural urban area. So it's just a matter of really knowing specifically what state and city you're in, and then how many other people require that same service. So Dallas, okay, where I'm at, is also a backlog at the moment.
Okay. Do you see any 485 adjustment status petition got EAD and advanced payroll without biometric?
Well, so yes. So there are, due to COVID-19, there are certain circumstances where if USCIS has, your biometrics on record, they can go ahead and issue EAD without the appointment. But that's a case-by-case basis, and that's, depending on whether or not, most all of our listeners who are going through this process, obviously, especially the spouse and kids, have had the biometrics. So, some of those circumstances that has been waived. It's not as maybe as many as we would hope, but that process has been helping keep the backlog moving in regards to that.
Okay. So I think recently USCIS has maybe released the derivative 485 application rejection can refiling, right? Do you have any additional information on that one?
So this was published or came out, I think, last week, and we heard about this from AILA, just like what we were talking about before, our hiatus here. AILA was working with the service center about these cases, and specifically at the moment, any case that had not checked for their derivatives family members to be filed as employment-based, all those rejected, they can resubmit. Now, I do want to recommend everyone remember that the Texas Service Center handles cases not just for employment-based, immigration, but they handle all sorts of other applications for adjustment of status. And in October alone, there was 419,000 cases that went through that lockbox. And, there's a lot of things that could go wrong and did go wrong. But at the end of the day, the service is trying to help rectify these mistakes and, make sure everything's being processed correctly. So at the end of the day, I think that, 99% of all the rejections, whatever happened, will already be accepted. You can, mail back in, and everything will work out in that regards.
Okay. If anyone follow this situation, maybe they can reach out to the attorneys or employees, so they can reinitiate the application, right?
Correct.
Okay. So only for derivative, maybe most of the cases are denied based on the did not check 3A and 9 Part 2 and 485.
That's correct.
485 application. So USCIS only consider those rejection, or it taking all other part of rejection?
So there's also other rejections that have occurred due to, financial instruments, payments. And that's also still being discussed at the moment about resubmission for that due to the fact of the length of delay accepting these cases. So we're expecting maybe additional information in the next week or 2 weeks on that.
Okay, it's a good news actually.
Yeah, it's good news.
So, yeah, yes, thank you. Lucas, I have a question. One of the applicant applied the AOS on 28th October 2020, by April 20th, it could be 6 months. Will complete it by apply the petition, right?
Right.
So if he want to move the other company, can he apply the supplement J, or with prior to get the EAD and advance payroll?
Well, so here it goes back to what we've also discussed in the past. Is the I-140 already approved? If this is a downgrade and the I-140 is pending, the petitioner at any time could just withdraw the I-140. So in the sense of that, you might want to make sure your I-140 is approved, and it needs to be approved for at least 6 months to prevent the petitioner from withdrawing that, to prevent you from porting the adjustment of status. But the portability for an adjustment, yes, is for 6 months after the adjustment's been pending. But the adjustment's only good if the I-140 is valid. If the I-140 is not there, adjustment's going to be denied.
Okay. If anyone applied in direct EB2 segment, can they apply the adjustment status after 6 months? Apply the petition without...
Yes. So the way this works is, after 6 months has passed, you go work for a different employer, and whenever you don't have to do anything. You might want to check with your employer to make sure that they would support you with the supplement J, but you don't need to turn that in until your visa becomes current. Once your visa becomes current, then you'll get a notification, even if you don't change employers, since it's going to take more than 6 months to process these for your final action date to become current. Everyone's going to get a supplement J request in the future to make sure, that they still have a valid employment opportunity. At that time, you would submit the new supplement J, and you would obviously want to consult with an attorney anytime you do switch employers, because you want to make sure that the positions relate to one another and can support one another, so there's no issue with the supplement J from one employer to another.
Yeah, okay. Yeah, thank you. Lucas, I have a very interesting question on visa interview. So just give me your suggestion, maybe just give me the more information on that. So one H1B applicant attended the Hyderabad consulate. Interview went well, and the consular officer told that visa is issued, and they kept his passport. After 2 days, they got the email saying that visa got refused, and submit some more details with the background information, kind of fast 15 years address and 15 years of employment information. Which situation they can ask this information about address and employment information in consulate?
Well, you have to remember the consulate, the officer's job is to make sure that you're admissible whenever they're issuing the visa stamp. So there's multiple ways you can be inadmissible, whether or not you committed a crime, if you lied or had submitted fraudulent documents or misrepresented a material fact. If you have certain health grounds, certain disease or something like this, that would have you be inadmissible. So if someone had, obviously we live in the United States, there's 50 different states. And within those 50 states, there's thousands of jurisdictions where we have local and city governments. So, let's say you had a ticket or you had some sort of a minor traffic offense or criminal offense. There's not like a national database that would have all this information there. So whenever they search a database, your name might pop up and the officer might want more information about where you worked or where you've lived to help make sure there's no other instances or that it matches the database. So a lot of these background checks are just that. They check the database and then they want to verify that information. Now, some other issues we've been seeing is a few people have been receiving rejections based upon, fraud or willful misrepresentation of a material fact. And what this means is maybe you worked for an end client. The end client is contacted by the Department of State, and they're going to say, hey, is this a valid position? Was Mr. Employee working there? So on and so forth. And if they say no or something else to that effect, then, you don't really have even if it's, you really work there and everything, you don't really have the platform to challenge that. And so, you can get all sorts of other, bad results from that. The good news is there are ways to try and correct this if there is a negative experience. It's not as easy as if you were here in the United States. So, we can't just go to court and sue or do anything like that. And the consulate office, pretty much what they determine is final. So what we would have to do is, coordinate with their help desk system and maybe verify, with a different officer that all the facts are correct, and submit additional evidence to help show that, whatever incident that one officer determined is not true.
Okay. Lucas, I have another question on H1 extension. One of the H1 applicant, his H1 is expiring in next 3 months. His passport validity till next, this is the March, right? Next June. Mm-hmm. If he apply June 2022, if he apply for the extension, H1 extension, will he get the, let's say we apply for the 3 years of extension, will he get 3 years extension or get until the passport expiry June 2022?
He should get the 3 years extension. And so just remember, basically the way this works is when you enter the United States, you're going to be issued an I-94. Now, the I-94 is going to be attached to a certain visa category, whether, a non-immigrant visa category such as H1B, L1, visitor visa, so on and so forth. Whenever you enter with an I-94 and a pass in that visa category for H1B, all you need is the I-94 in your passport to legally work. Where we get into these extensions is we're requesting USCIS to go ahead and extend the time on the I-94. Now, your I-94 can be transferred from old passport to new passport, whenever you file an extension or amendment or whatever it is. So what I would recommend is, obviously you want to renew your passport 6 months. I think India requires 6 months, if I remember correctly, and then, work with the office to try and expedite it as soon as you can, so you're not waiting till last minute. I have had a couple of people where they just don't even realize it's going to expire, and we go to file an extension, they have an expired passport, and that causes issues at that moment. But if you still have like a year before your passport expires, it should be perfectly fine to get the 3-year approval.
Okay. Yeah. Thank you, Lucas. Thank you for today's session. We know that you are busy for filing fiscal year 22 H1 process. So we can connect next week and we can continue to every Wednesday and same time, same platform. So maybe you can share before closing the session if you want anything.
Yes, I want to thank everyone for paying attention and watching our show. Obviously, if you have any ideas or topics you'd like to discuss, please, post to our page or let Venkat know, and we can, dedicate that time to those topics. And even though I do want everyone to remember, there's a lot of positive changes that are happening right now because of maybe a new administration. Certain regulations are changed or rescinded. But there's still other regulations that can impact your ability to be admissible to the United States. So it's very important that we don't let our guard down or we don't relax. We need to always be diligent with making sure everything's correct in our record and all the information is correct when we go for these appointments. to avoid any trouble. So with that, I appreciate the time, Venkat, and as always, it's a wonderful platform, and hopefully we're doing our best to serve the community, sharing these topics.
Yeah, we thank you for you came our platform and giving more information on the immigration system and addressing more scenarios and questions. We're very thankful to you. So, like as we said, right, we continue this this session every Wednesday, and we can come up with the more information, more updates, and we can try to simplify the USA immigration system. Thank you very much. Until next week, bye bye. See you.